You're welcome. Good morning, and you're welcome to.
Morning.
The floor is yours.
Thank you. And may it please the court, my name is Donald Vowell, representing Ms. Frances Owens, and I do request 3 minutes for rebuttal.
3 minutes, certainly.
We have a med mal case dismissed on summary judgment. It's on subpart B of the act. That is, who can testify as an expert. It's not based on subpart A, which is what they can testify about, what we would have to prove. So there are 3 points to consider, of course, on the subpart B. You have to be licensed to practice in Tennessee or a contiguous state. It has to be a profession that would make your testimony relevant, and you have to practice this profession during the year prior to the injury. So the injury is bed sores or pressure wounds. Happened in the middle of 2016. The expert, Ms. Camborian, is a licensed registered nurse, actually a wound care nurse. Seems relevant. She practiced that profession throughout the year 2016. And obviously during the year preceding the injury. So, why are we here? The trial court said that her testimony would not be sufficiently relevant. Now, that's the statute, would not be sufficiently relevant, subpart B of the statute, to substantially assist the trier of fact. Now, that is Rule 702 of the Rules of Evidence. So we kind of have a blend of the statute and Rule 702 and 703.
The statute tracks the language of 702.
Say that again, Judge McBrayer. There's an echo.
The language of the statute tracks Rule of Evidence 702 is what you're saying.
No, I don't think it. I would need to grab the rule and look at it, but I don't think so. I don't think it tracks it. The Rule 702 talks about trustworthiness. The statute talks about irrelevance. If I'm following the question, that's where I'm saying. So that's why I'm saying it's a blend. The judge, this is the court's words. They would not be sufficiently relevant to substantially assist the trier of fact. So I think we're blending the statute with Rule 702 and 703. The court went on to say, and that her experience working in non-hospital facilities, even though dealing with wound care, lacks sufficient trustworthiness to allow her testimony to be allowed under Rule 702 and 703.
Counsel, is there any reference to Rule 702 and 703 in the summary judgment motion
there
or supporting memorandum? Or?
Yeah, there wasn't, and that's one of the reasons that we're here. And I'm sure this the court is aware, but there's a big difference in trial and summary judgment. If you're having a trial, you have to approve everything, every element. But
in terms of the statute, the statutory provision, subsection B portion, and the profession, part of the summary judgment order in this case addresses not nurses' actions, but also the suit insofar as it touches upon OTs, PTs, dietitians, physicians, administrators in the hospital. Do you, in your appeal, are you raising any objection to that portion of the
we're not here on that.
Okay.
No. So, summary judgment is obviously different from trial, because summary judgment, you just have to defeat or defend against what the other side has raised. And the other side did not raise Rule 702 and trustworthiness. So that is, very much part of why we're not the only reason we're here. That's very much part of it. So, so I have this question. The statute says you have to have a relevant profession. Isn't nurse a relevant profession for bed sores and a wound care nurse? I mean, the injury is a wound. How's that not relevant? And she worked as a wound care nurse during the year preceding. And don't wound care nurses know how to take care of wounds? So
The court counsel seemed to be focused on the difference between a hospital and she was in a rehabilitation center the year before. Is there enough of a difference between those two things that it makes her not applicable in terms of testifying as to the standard of care?
Your Honor, the testimony from Nurse Camborian was that there is no difference in how you treat bed sores in a hospital versus a rehabilitation center, a step-down unit. You know, they get patients 24 hours after surgery. There's no testimony that the beds in a hospital are any different. You know, the people's skin is the same, you know, wherever you are. So that is also very much part of why we're here.
Is this case just about the treatment of bed sores, or is it also about the prevention of bed sores?
It's probably more about the prevention, because, you know, she shouldn't have gotten them, and I think this was stipulated that she got them, you know, for purposes of this motion, that she got them because of, you know, the not being turned.
And so how do we know, I mean, I understand your argument is that the setting really doesn't matter in this case, where your expert practice before this injury occurred is irrelevant because you're treating all patients, whatever the setting, exactly the same. How do we know that going into that? I mean, wouldn't that have been something that we would have put in an expert's declaration, not in response or in a motion to alter amend, but rather in response to motion for summary judgment?
Because, Your Honor, it wasn't an issue until the motion to alter or amend, until the court issued the first decision. You know, the court issued 2 decisions and later abandoned the first decision. The first decision had at least 3 issues that weren't raised in the motion. You know, the locality rule, there was the national standard of care, you know, and the lack of trustworthiness. None of those were raised. And so there was no occasion to file this declaration. Again, a summary judgment, we must defend against what is thrown against us. We don't have to prove, you know, every element of the case. So that is my thought on that question, Your Honor. So the question is, was the court really talking about competence to testify, or was the court talking about standard of care? So I've got 2 points I would like to mention about that. The first being from the order. The order says here, okay.
Proceed.
Here, Nurse Camborian, this is the order, testified, and it's the amended order, I think, testified that the only basis for her opinion concerning the standard of care in a hospital setting is derived from her work commencing 2017, well outside the statutorily limited period preceding the injury. So I think this is standard of care. It's not competence, it's standard of care, what's in subpart A. And not only that, the court is saying that you have to already know the standard of care when the accident happens, which is not the case. So the second item I'd like to mention is this is from Vanderbilt's memorandum. Says, this is 1 TR 24. Ms. Camborian is similarly incompetent as a matter of Tennessee law, they say, Ms. Camborian has no relevant knowledge and no relevant experience of the standard of care for hospital employees during the year preceding. And this carries over into the court's opinion. You don't have to have experience of the standard of care in the year preceding. You can learn the standard of care later. You can learn that later. And so I think this is, very much we're talking about the standard of care rather than competence to testify. The other thing, or the next thing I'd like to mention, I guess we already talked, what standard of care are we talking about? As we talked about earlier, it's the standard of care we think for patients in bed in institutions. Doesn't matter what the institution is. Now, if the question is hospital, does she know anything about hospitals? If that's the question. She worked at 6 hospitals, 26 months. So I don't get that as a problem. So then we have the due process problem that we already talked about. I put the case law in the brief. You can't dismiss a case. A trial court cannot dismiss a case sua sponte on summary judgment unless there's notice and an opportunity to respond. So it was dismissed on 3 grounds the first time, sua sponte, with no opportunity to respond. And the second time, maybe 1.5. Part of it got left behind. There's, if I've got, well, maybe I probably don't have time to open a new subject, but a lot of this was not even mentioned in the statement of uncontested facts that the other side filed. Summary judgment, you have to put this is Tennessee, this is not the federal, everything has to be, every fact, separate numbered paragraph in the statement of uncontested facts. If it's not there, the court cannot grant summary judgment. But there were at least 3 incidents, which they're all in the brief, that were not there. And yet we have summary judgment based on those they're all mentioned in the court's opinion.
All right, thank you. We'll hear further on rebuttal.
Thank you, Your Honor.
We'll now hear from the appellee. Good morning, Ms. Tipton.
Good morning, Your
I
Honor.
trust you're going to keep Mr. Anderson quiet.
I'll try my best.
Very
I make
good.
no promises.
Excellent, thank you.
This case, as Mr. Val mentioned, is a case regarding a summary judgment motion. That's why we're before the court. But the issue of summary judgment really is kind of on the back burner. The main issue is whether this expert, their sole standard of care expert, Ms. Camborian, is competent to testify as an expert in the state of Tennessee under Tennessee Code Annotated 2926-115B, and is raised whether or not her testimony, if competent, if her testimony would be admissible under the rules of evidence 702 and 703.
Counsel, would you agree that 702 and 703 aren't referenced in the summary judgment motion or the accompanying memorandum in support of that summary judgment motion?
They're not explicitly referenced, and I think Judge McBrayer hinted on this point maybe a little bit and asked about whether or not 702 and how that's combined with the statute, Tennessee Code Annotated 2926-115. And as we mentioned in our briefing, they're really implicitly interrelated because you have to have knowledge of the standard of care and been working in this profession or specialty in the year before in order to be able to substantially assist the trier of fact, to be able to give testimony.
Counsel, insofar as 702 and 703 extend further than the statute, your brief suggests that the motion to alter or amend is an adequate substitute, essentially, that they had an opportunity to address these issues. I'm struggling a bit with that. Motion to alter or amend, my understanding is motion to alter or amend, you can't raise new arguments. So I'm a bit confused how you address an argument that wasn't previously raised in a motion where you're not allowed to raise new arguments.
This is a great question, Your Honor. And in this case, in the motion to alter or amend was 16 pages, the memorandum, and it did, in fact, go into 702 and 703 and the locality rule, Tennessee Code Annotated 2926-115 subsection A, and provide arguments of why either the motion for summary judgment should be set aside and reheard, or whether it should just be set aside because there were not grounds that Ms. Camborian her testimony would be admissible.
Under this court's prior decisions, though, that a motion to alter amend shouldn't have extended into new arguments, right? I mean, we're beyond sort of the reach of what a motion to alter amend is used for under Tennessee law by raising new arguments. Am I correct on that, or am I misunderstanding something on that?
And that may be a case, but in this particular instance, those arguments were raised, whether or not they should have been considered by the court because they were outside the context of motion to alter or amend. They were raised, they were heard, and they were considered. Without that, even with the 702, 703 issue aside, which I think is important, as a gatekeeper for the court, the trial court, in determining whether an expert can give testimony has to determine two issues. First, are they competent under 115 subsection B? Only if they're competent does 702 or 703 even become relevant. So really the 702, 703 issue is purely academic if Ms. Camborian's not competent under the statute. And going back to the competency issue, which I think is really the main crux and really the primary question that has to be answered is, did the court get this right? Or was there an abuse of discretion in holding that Ms. Camborian was incompetent under the statute? Mr. Val has focused a lot on the injury, on the fact that there was a pressure injury. Yes, there was a pressure injury. But the focus isn't on the injury. The focus is on the defendant's practice and the care that's being provided. In this case, the defendant is the Vanderbilt nurses that provided care in a post-operative setting in a hospital. That's what we have to focus on is Ms. Camborian, did she work in a profession or specialty that gave her knowledge of that field in the year prior to July of 2016? And she was asked that during her deposition. And there's lots of issue and lots of distraction, as you read in the briefing, about this question. Was it a bad question? Did it assume facts that weren't in evidence? Well, first, prior to this testimony, and it's in our statement of undisputed facts that were either admitted or admitted to by the court for failure to comply with the rules, was the admission by Ms. Camborian that she had only ever worked in a hospital when training to be a nurse, which she became a nurse in 2011. So she hadn't worked in a hospital in the 5 years prior to the care that's at issue. Moreover, the question doesn't even matter. What matters is Ms. Camborian's answer, and she was given free latitude. What makes you qualified to provide standard of care testimony in this case? And she said her job at Manicare that started in 2017 to 2020, a year after the care in question, which was July of 2016 at Vanderbilt. Her testimony in and of itself, which plaintiff tries to avoid because her own admission is game, set, match in this case. Her own testimony shows that she did not practice in any field that would be relevant or special or specialized to give testimony as to the Vanderbilt hospital nurses in a post-operative setting in the year prior to July of 2016.
Counsel, if her testimony is that the conditions in a rehabilitation care facility are the same as a hospital with regard to addressing pressure wounds, isn't that sufficient to at least qualify for the requirements under the statute that she was working in the profession, the same profession?
There's 2 points to that question. Number one, that testimony only came in her declaration that was submitted with her motion to alter or amend, which we have pointed out in our brief was untimely. She had to offer any and all testimony under Tennessee law to establish that she was competent under the statute in response to the original summary judgment motion. She did not. So we have the untimely issue. Outside of that, in her declaration, it doesn't go into any specifics of in that year prior what she was doing or how it was the same or how it was relevant, nor really can she because she didn't work in a hospital in a post-operative setting in that year prior. Like her hospital experience was either from her training in 2011 and before, or 2017 and after. And it still goes back into that 1 year prior.
And so you're saying, is that the key here? It has to be in a hospital, in a post-operative setting. You're saying that's what you need expertise on. In a hospital, post-operative.
In this case, yes.
So I'm assuming then that would have been very clear in your motion. That's the reason you're attacking this expert.
Correct, Your Honor. Under the statute, under Tennessee Code annotated 2926 with 115, the focus is on the professional or specialty that the defendant practices. So that's why that key of that setting is critical, because just because you're a doctor or a nurse doesn't mean that you know all of the standards of care and all of the care that must be provided in all settings. A walk-in clinic doctor isn't going to know what an ICU doctor and know the type of care that needs to be provided.
The case you've cited in your brief references a physician that's essentially disqualified in terms of not being knowledgeable, for example, about bilirubins and jaundice. And the focus there seems to be, is this professional engaging in the type of work that is at issue? That doctor wasn't treating newborns that had jaundice, had issues with bilirubin levels being too high. Here, isn't this expert doing exactly what they're testifying as to in terms of their profession? They're addressing wound care and turning patients, and they're engaged in the same profession in line with the Court of Appeals decision you've referenced in your brief.
I think there is a difference in this case. In this case, the focus just isn't on preventing wound care in a post-operative hospital setting. You're focused on, is the patient responding well post-operatively? Are they, having any negative effects to anesthesia? Are we able to get them up and get them recovering quickly? Are their nutrition needs being met? It's not solely the focus of preventing a pressure injury. It's the total care that's being provided. And the fact that
It almost strikes me as we need an expert to tell us that why that distinction is important here. Here at the summary judgment level, I'm not sure I understand why. I hear what you're saying now, but don't we almost really need an expert on the nurses side, the hospital Vanderbilt side here, to say, this is why this level of expertise is significant in this case. And we really just don't have that. We have, even in your brief where you say these different settings are important, it's almost taken like a truism, like, of course we should know that there's a distinction in levels of care depending on the setting here. But, how do we know that without some expert help on it?
I think it comes, back to Ms. Camborian's testimony in her deposition when I asked her what made her qualified. And she again stated that it was her job at Manor Care, where she worked in a step-down unit in 2017 to 2020. That testimony satisfied the burden of basically establishing that what she's claiming makes her knowledgeable was not in the 1 year prior, which triggered the plaintiff's response to come back and say, no, it was good enough. What she was doing was sufficient with that burden shift, and that did not happen in response to the summary judgment motion. And that was their obligation, was to offer all evidence to make a full response to our motion at that point, and not in a motion to alter, amend, or later subsequent methods. We've skipped through a lot of what I was planning on to discuss, so I'm trying not to rehash any grounds.
You've got time, and we'll give you a moment to regroup since we've distracted you. I do want to say while you're doing that, Judge McBrayer, your questions are coming through loud and clear, and I'm pleased to say the quality of the video hybrid remote hearing is working quite well.
Judge, I apologize. My cough also came through loud and clear. My apologies.
Well, we'll put that in your personnel file.
I'll try to remember to mute next time I got the call.
In closing, I think I would just reiterate that the trial court, with its competency analysis, given the testimony of the expert in this case, looked at this, and her testimony was very clear. What she was basing, what she thought made her qualified, was care that occurred after the fact, experiences that occurred after the fact, and that's not in line with the statutory requirements of the legislature. And I think the court looked at this very closely. It didn't take it, looked at everything was before him, and looked at the cases and the fact that you have to have experience in the year before and a profession or specialty that is related to what the defendant was providing, in this case, a hospital setting, which Ms. Kimborn admitted she did not have in that time frame. And I would also note that I think it was mentioned in the briefing, but I do not know if it's been mentioned before the court today, that this is an issue that's an abuse of discretion standard, because we're focusing on issues of expert competency and admissibility of testimony. It's not just a summary judgment de novo. That's, again, kind of separate down the road only if we get past the competency, and 702 does it become de novo issue. Vanderbilt requests that this court affirm both the ruling on, obviously, the Tennessee
Counsel,
Code.
on the standard review, abuse of discretion under 702 and 703, or also under the statute?
Also under the statute, relating to, under Shipley, actually, it's under Brown versus Crown Equipment Corporation, 181 Southwest 3rd 268, which is a Tennessee Supreme Court case from 2005. The determinations regarding expert competency as well as the admissibility of testimony. So 702, 703 are both abuse of discretion analysis.
What about the statutory provision, though? Not 702, 703, but
competency is
okay.
also an abuse of discretion. For the reasons set forth both in our briefing and today, we ask that you affirm the grant of summary judgment to Vanderbilt based on the determinations that Ms. Kimborn was not competent or her testimony as an expert was inadmissible. Therefore, Vanderbilt had negated the elements of plaintiff's burden. Thank you.
Thank you, Ms. Tipton. And Mr. Vowell, you have time for rebuttal. I should also thank you for keeping Mr. Glanton quiet during the argument.
I haven't heard him say a word.
Yeah, so the court is most appreciative of you as well as Ms. Tipton.
Thank you. So the only thing I want to talk about here, whatever, if you have a question, but this question, their whole thing is hinged on this kind of, I don't know whether to call it an unfair question or go further, but for the moment I'll stick with unfair. Here's the question. And given the fact that you've never worked in an inpatient hospital setting, that's not true. So we're asking a question that's not true. The preface is not true. And we're going to try to make a lot of hay with this question. What makes you qualified to give an opinion regarding the nursing standard of care in a hospital? Well, again, you're making an assumption here that is the standard of care. When, we've already argued, we think it's the standard of care for taking care of patients who are in beds. And I think... Didn't
they rely on that passage in the motion for summary judgment?
They did. It's in their, it's at least, this question at least is in their statement of uncontested facts.
Yeah, so I'm wondering why that wouldn't have been the alert saying, well, wait a minute, there's a lot of problems with this question, so we need to be all over that in our response. First of all, we did not, it's not correct that our expert has never served in a hospital setting. When she was younger, she trained in a hospital setting. And secondly, that it doesn't matter whether it's a hospital setting or not for this purposes. It is, the beds that matter, or just the patient that matters, the type of patient that matters, and therefore the setting is irrelevant. I mean, it seems like to me that would have been set off some warning signals that we need to address that more specifically in our response to the motion for summary judgment. Why am I wrong about that?
Well, the thing is, the court accepted that as true, and it's not true. The fact that you've never worked in an inpatient hospital setting, how can the court base the fact on the decision on that? So the rule question, if you can win a case with a question like this, I shouldn't say I'll be surprised. I think it will be, you shouldn't be able to. You shouldn't be able to pull that off. But
Really, I mean, I guess this gets to the crux of this, right? This is unusual procedurally. Typically, if you're moving for summary judgment on expert, it's because the other side just doesn't have an expert, period. This is a little bit different from that. This is almost like something you would argue in a motion in limine, right? And then if you lost that, you would have a chance to come back and get another expert. But in a summary judgment, the court agrees with the other side, you're just done.
if you have been put on notice of the grounds, the whole grounds of the dismissal, you might be done. If you haven't, I would say you're not done. And if the fact then that the court finds is not really true. See, the court found no, I didn't bring this back up here. The court found something like no, never worked in a hospital. I think that's part of it. That simply isn't true. And so in this thing that was in the statement of uncontested fact, it does not say, paragraph 7, this nurse never worked in a hospital. It just has, number whatever this is, it just has the question and the answer. That's it. So you can only, you can only build on a foundation as, if the foundation is no good, you can't get anywhere. So I don't think they've gotten anywhere.
All right. Thank you, Mr. Vowell and Ms. Tipton, for your arguments. We will take this matter under advisement.
Thank you.
Thank you. You're free to go. We have one more case on the morning docket, but we must take a recess before we hear that. Is there anyone here for the third case, the N. Ray Josiah? Okay, very good. Well, we'll be back in 10 minutes in any event. All right, thank you.